Do we have a tech? Oh, yeah, okay, we're all set to go. Good afternoon. My name is Kate Bartlett. I'm the Dean of Duke Law School, and it's really my great pleasure to welcome you here to the 5th Annual Herbert L. Bernstein Memorial Lecture. This lecture celebrates the life of a professor who enriched this school for 17 years. Professor Bernstein was a fantastic teacher and a scholar in the areas of contract law, comparative and private international law, and other fields. He was born in Hamburg, Germany, was educated at the University of Hamburg, and later joined the prestigious Max Planck Institute for Foreign and Private International Law. He came to the United States in 1962 to study at the University of Michigan, and before coming to Duke, taught at the University of Hamburg, Berkeley, and the University of Southampton. It's not an overstatement to say that everyone loved Herbert Bernstein. His students loved him for the quality of his teaching and for the respect and warmth he showed them. Likewise, the faculty and staff at this school loved him for his kindness and support, his passion for history and law, his commitment to tolerance and justice, and his humor. He was a very funny man. This series is sustained through the contributions of many of his friends and alumni of this law school. It is our great honor and privilege today to have as our Bernstein lecturer Dean Zhu Suli of the Peking University School of Law. While I have come to know and greatly admire Dean Zhu, and we're in the process of developing a memorandum of understanding between our two law schools, I have invited Professor Jonathan Ocko, who teaches Chinese law and society here at the law school, to introduce him. Professor Ocko has degrees from Trinity College and Yale University, and he's a scholar of modern Chinese history and law. He's the chair of the history department at North Carolina State University with a joint appointment at this law school. He has deep ties to China, including ties to many of this law school's Chinese alumni, and has been instrumental to Duke in expanding our relationships with Chinese universities. So I will give you Professor Ocko.
I'm going to make this very quick so we can move to Dean Zhu's talk, but I just want to note a couple of points. First, this special meaning for me because I was one of the faculty who loved Herbert, who was enormously helpful in talking about comparative legal issues, and also my son was a student here at Duke Law School of Herbert Bernstein, and I heard endlessly about how I could improve my teaching techniques by coming to watch Herbert teach. I'm not going to run through Professor Jui's biography. It's part of the publicity materials. It's part of the brochure that's out. And for the faculty and students, I think many of you read the review of Professor Jui's most recent book, Taking Law to the Countryside, that was sent out by Chun Hu from Judy Horowitz's office. So let me just, there are a couple of points I want to make in introduction to Professor Zhu. One is that it's not simply the case that he's returned to his alma mater, Peking University or Beida, to be the dean. If one reads his remarks to incoming students and to graduating students, it's clear that he is deeply emotionally attached to his alma mater and extraordinarily passionate about the role that its students can and should play in China's evolving legal system. And this comes through, I think, most recently, if you have a chance to look at his remarks on the problem in China of the oversupply of law school graduates, which was hardly the problem when I first started studying Chinese law. Secondly, and I think this comes through in the materials that were distributed, his view of the law is a very pragmatic one. In his writings over and over again, he talks about we have to figure out what China in this time of, to use his language, uneven development needs to do. So that China needs to think about creating a diverse legal profession, a diverse group of judges, one that raises the professional and specialized level of judges at the higher levels, and yet also provides enough good judges at the local level. And when he talks about the local level, in a recent piece he wrote about a model local judge, he said, that maybe it's okay to focus on mediation. You don't have to apply Western rule of law theory. You don't have to apply formal legal reasoning. What you need to do is solve people's problems in a way that they recognize as fair and just, in a way that they recognize that comports with their own norms, with the moral values of the community. And so that, maybe what lawyers ought to be doing is not writing about rule of law, but they ought to try to understand the nature of this local knowledge and to work to systematize it so that it can be used in a very effective way in the locality. The third point I want to make about Professor Jui, and he seems so nice, it's hard for you to understand this, but if you talk to his colleagues in China and you read his stuff, you get a sense he's a little bit of an intellectual bad boy. In the sense that, to quote Frank Upham, the professor of law at NYU, that Professor Jui is irritating and fun. And I think what he meant by irritating was that Professor Jui is a contrarian. He likes to provoke, he likes to prod, he likes to sometimes suggest, listen to what other people are saying and then take an alternative point of view. As one of my Chinese friends suggested, that may be why Professor Jui likes Judge Richard Posner so much, that he's kind of found a soulmate in Judge Posner. It comes to discussions of rule of law. He takes a kind of contrarian stance on this, and also on an issue that many American scholars emphasize, the need to get rid of all of the retired military officers who serve and have served as judges in China. Professor Jui has taken, again, a contrarian position, totally at odds with his colleague He Weifang, who, if you read the New York Times, is the only person they ever cite on Chinese law, who argues that all these judges have to be replaced, and Professor Jui suggests maybe we ought to put these people out in the countryside. They know something. Give them some legal training. Put them to work. Nobody else wants to go to the countryside to work, and yet people need adjudicators. So we should put these people out in the countryside. His latest book, he's moving into the area of law and literature, where he's been involved, before, drawing on materials from Chinese plays, and it's a scholarship that has enormous breadth. Even if you can't read Chinese, I encourage you just to flip through it and to flip through his writings on the web on the issue of law and literature, and just look at the range of English language citations that he has. It's a very useful bibliography for you, even if you can't understand the Chinese. Today he's going to be talking about political parties, and I'm sure some of you were puzzled by why there is a plural there, because he's also going to be talking about the Kuomintang. And he's going to not sort of give you an overview of Chinese history or Chinese law, but rather try to introduce a comparative framework. How do we think about the issue of political parties and judicial systems? So it will be interesting to see the approach that he takes. He notes in his writing that one of the reasons he likes Posner is that even though Posner is a libertarian anti-Marxist, that Posner employs the analytical approach of historical materialism, so that Posner may not realize it, but he sometimes thinks like a Marxist. So with no further ado, I want to introduce and be honored to welcome Professor Zhu Suli. I'm sure his talk will be, as much of his writing is, provocative, penetrating, pragmatic, and perhaps even Posnerian. Professor Zhu.
Thank you very much, Dean, and thank you very much, Professor Ocko. It's a great honor for me to be here to deliver the 5th Herbert Bernstein Lectures. I want to discuss today is about the political parties in China. Very important issue for China's legal reform, but also for Chinese and for American and other foreigners to understand China, understand China. And also, I believe it's very important for for comparative legal studies. And the lecture came out because after my reading the Professor Frank Ubben's book review of my article, my book, Sending the Law to the Countryside, he criticized me because he thought the book is absence of political power in this book. And he charged me a little bit coward or not brave enough to analyze Chinese political influence in the Chinese judiciary. But I think that his argument, his criticism is untrue, because I presented so much political analysis in the book, and I think Chinese judiciary bear too much burden, political burden, in its performance. But what's his point is I should spend 1 or 2 chapters to analyze the political, especially Communist Party's influence and the intervention of the judicial performance at the basic level court. I think his criticism is right, but at the same time, I found it's hard to do, because I found he has made 3 misunderstandings. One is he underestimates the pervasive influence of the Chinese Communist Party in China and in China's judiciary. Therefore, it seems him that I can spend 1 or 2 chapters. It's enough to analyze the Chinese Communist Party's role in China's judiciary. Actually, I cannot, since the CCP's ideology and policy and political organizational structure is omnipresent in the China society and the Chinese judiciary. But on the other hand, I don't want to give more example or give a descriptive presentation about how the Chinese Communist Party has such a broad influence and in judiciary. But on the other hand, Professor Upman exaggerated the dominance of CCP in China and in China's judiciary. It is true that China is a country under the leadership of CCP, and the CCP has the most strong influence over everything. But we shouldn't conceive CCP in an essentialist term. It is a party consists of individuals who have different background and educations with different political, professional, and even the personal interests. So within the party, there's so many struggles, conflicts, and different ideologies. For example, I was conceived as a conservative, but my colleague, my good friends, Hui Fang, was considered a radical. But we are good friends, and we are, both of us are Communist Party member. So it's you cannot use the CCP in essentialist terms. So it's very hard to categorize them with a simple word, Communist Party or Communist Party member. At the level of everyday experience, communists are about the same as the other common people. Further, because of Professor Frank Upman's decontextual understanding of CCP and China's judiciary, I believe he failed to appreciate the positive importance of CCP in China's judiciary development and reform. In spite, he pointed and correctly pointed up the negative influence of CCP over China's judiciary. But I want to say we tend to overlook the positive influence of CCP. Although Professor Upman's research background may explain his understanding or misunderstanding China's judiciary. But such flaw could fall upon anyone who is not familiar with China. So I don't want to blame Professor Upman simply because I'm insider of China. Such a criticism, I believe, is intellectually not constructive and difficult to judge its validity. But what is important is that so many foreign legal scholars interested in China tend to share Professor Upman's view about China and China's judiciary, even though they made effort to be impartial and kept their academic honesty. So the question becomes what to make these honest legal scholars reach a conclusion about China, such a conclusion about China underestimated, exaggerated, and other mistakes. The problem even goes deep because there are many Chinese legal scholars who feel so awkward to deal with the relationship between the CCP and China's judiciary, because the CCP, the influence over judiciary is evidently everywhere, and it's very difficult for Chinese legal scholars to fit the China's judicial reality into a theory or model of judicial independence. So Chinese legal scholars tend to see the CCP influence over judiciary as an abnormality, a deviant, unfortunate historical event happened in modern China and should be corrected by the efforts of my generation of legal professionals or law professors. But on the other hand, some other Chinese legal scholars propose, on the one hand, Chinese legal scholars propose a radical judicial reform plan, which is evidently impossible, but more important, impractical in face of recent year, the widespread corruption of judges, and even though the CCP's direct control and intervention of the case adjudication reduced substantively, and many judges gained much more independence. So more independent judges, but they didn't make a good decision. So corruption is widespread. Some other Chinese legal scholars simply ignored the CCP's role in the judiciary. They don't give, in their books, they don't mention the CCP. Not because their timidity, but because the theoretical model they adopt and they are used to, which is basically is an American model, doesn't provide a space for such a communist party to play a role in such a model. So the work of Professor Upman and many other Chinese and foreign legal scholars troubles me a lot. The problem they share, in my view, is that they took the Western countries' model of judicial, how the development of the judicial independence and the practice of judicial independence, take such a model for granted. So when they study China's judiciary, the question becomes whether China's legal practice or judicial performance meet the so-called universal standard of judicial independence. If not, then the task for this legal scholar is to identify the individuals, organizations, political parties, or other social entities that inappropriately influence the judiciary, then the effort should be made to reduce such influence or to remove such influence. No matter such influence, whether it's possible or impossible to remove it. Such an effort may be right in some other social contexts, but I want to argue it's a mistake in contemporary China. The effort presupposes that there is a judiciary in China consists of independent, accountable, well-trained, well-qualified legal professionals. And also it presupposes CCP is otherwise separable political organization or political entity is separable from the judiciary. So if you can, there is a independent judiciary who is controlled by the other entity, political parties. So then you can find the easy way to solve the problem of judicial independence in China. If you cut off the influence from the CCP, then China's judiciary will be independent and will work well. I believe this presumption shared by most legal scholars studying China judiciary are a mistake. The basic issue is there wasn't such a judiciary there, was not such a legal professional there. The traditional China has no separated judiciary, and there is no more modern legal professionals who have legal professional knowledge, skills, individuality, and modern conception and understanding of the society, state, and legal profession. The history of modern China began from the two most important political party. First is the Nationalist Party, the Kuomintang, and should say the Communist Party come first, and that's 1921. Then under the help, with the help, assistance of the Chinese Communists, the Kuomintang had the first national conference. The state and the government of modern China and all the other modern institutions, such as military, judiciary, civil bureaucracy, and other major professions, came after the political parties. So the political party, Chinese Communist Party, came first in 1921. Then it win power, over the power, is 1949. In 1927, it established the Revolution Red Army. Then after 1949, there's judiciary and civil servant, various government administration and agencies. In the Kuomintang, it's about the same. Kuomintang came, convened its first national party conference is 1924. It took over the power in 1927, and thereafter the judiciary and the civil servants developed. So it's this. So these modern professions are evolved and developed in a country of party state. That's China's very unique phenomenon in China, party state. First have the party, then you have the state. This makes great difference from the most Western countries, even from the former Soviet Union. In Western countries, too much generalization. The general pattern is judiciary, legal profession, and other professions come first, gradually evolved in the society. Then the modern political parties came after, when the judiciary has established itself and possessed sufficient political prestige and professional knowledge and skill, which can use effectively to resist the political influence and intervention of any political party. Even in the Soviet Union, before the Russian Revolution, the legal profession, the bureaucrats, and the military officers were already there. So the Soviet Communist Party, when they took over the power, they sent their party members, party representatives, the commissars, to judiciary, to the government agencies, and to army, to supervise the professionals and try to implement this the Soviet Communist Party's policy. This is most evident in the Soviet Union's Red Army. Many first generation of Soviet Union's high-ranking military officers were former Imperial Russian military officers. The first 5 marshals, three came from the Imperial Russian Army. All of them are graduated from the military college of Imperial Russia. But in China, the situation is very different. Neither Nationalist Party or the Communist Party has very weak, very few professionals of any kind, even without the military officer, trained military officer. Especially for the Chinese Communist Party, when they took over the power, they have no legal, any kind of professionals, probably very few educated people, but not professionals. The army, the generals are fighting in the field, then developed themselves. They are not the typical military officers. Some of them have a very low education level. Even the first generation of China's diplomats, they were selected from the generals and trained briefly, then sent to the other countries. So first generation of professionals in either Republic of China or People's Republic of China are party members, are loyal to the parties, or the military officer under the leadership of the party. So either Kuomintang or Chinese Communist, it's about the same. And I cannot present here about how both parties' charter shared so many comments about their organization, about their ideology, about the organizational group, the principle of organization. So they shared so many comments. Party in within such a party state, the party's political influence is natural and pervasive in all kinds of professions, in all branch of government, also in the judiciary. So for China, the most judges are Communist Party members, probably 80% or 90%. 10 years ago or 15 years ago, probably 100%. Only very few non-Communist Party members was selected as a judge, but they are normally communist. Even, for example, although they are not a Communist Party member, eventually they probably will be called as a communist. For example, recently, several years ago, the vice chairman of China, People's Republic of China, is China's largest entrepreneur. But he was called a communist. So in China, the communist is not like the Western intellectuals conceived. It's very different. Therefore, for China's judicial independence, to develop an independent judiciary means a very different path dependence from the Western model. As mentioned earlier, the Western model is judiciary and legal profession come first, then the party, political party. But in China, the political party, all the professions and other government civil servant developed, evolved within the party. The issue is not how to keep judicial independence, but how to evolve an independent judiciary, legal profession, and many other professions in such a society which is dominated by the political party, one dominant political party. So the question is whether it needs such an independent judiciary or legal profession. I believe we need. But the question is how long, how to transform China. I believe it takes time. And also I believe it's possible because China's ongoing social transformation and the social demand for such transformation is very high. And also I believe the CCP, although there's so many bad things, corruption within the party or within this government, but the CCP still, at least historically, it is a revolutionary party. It is its political ideology is political goal is a modern China. But I leave this issue here, and I want to emphasize the other things. If we found China's judiciary, the involvement and development of judiciary is within Chinese context, the question for legal scholars, therefore, is to study the development of legal profession and independent judiciary in China, rather than to use and sometimes impose the Western model of judicial independence to China, and try to develop some plan to help China to evolve an effective independent judiciary. I don't believe such a plan will work. Although I believe we can use the Western model to measure China's shortcomings, to criticize China's, and give us some imagination. But it is very difficult to use such a model to transform China's judiciary. Finally, I want to emphasize what's the importance of your lecture. First thing, because I mentioned that it's important for comparative legal studies. First thing, I didn't use the ethical-centralism argument against Frank Abben or foreign legal scholars, although I believe they made mistakes. Why? Because I believe the ethnocentrism, such an argument, is a political one. It is not a reasoned argument. You can argue because I have a special position, so I understand something more than you. I don't believe such an argument is intellectually challenging. I try to present a picture or explanation which may not be right, but based upon historical facts, based upon the so many materials, so evident facts. Everybody can see the difference for China's development and Western development. So such facts can be re-examined by other scholars. So I believe this kind of presentation will be can be used in other comparative legal studies. The second thing is, although I think China's judiciary and the path to judicial independence in the future different from the Western model, but I don't see it is a mistake, as so many Chinese legal scholars think China made a mistake, historical mistake. I don't see it is a mistake to be corrected, but rather I see the significance for legal research and for legal scholars. In my view, China's experience have great potential to develop an alternative theoretical framework for studying the evolution of legal profession and the independent judiciary in many other developing countries. Those developing countries, more like China, is agricultural society. There is no modern state, no modern government, no legal profession and other professions. So China's experience may provide a better perspective and a more convincing explanation of the performance of judiciary in this country. And also it may provide some more practical answer to the problems of judicial independence so many people criticized in developing countries. So the problem of China's judiciary or China's judicial independence may be a mine for Chinese legal scholars' future studies. So I believe that's important. But I just present an alternative approach to look at China. It doesn't mean my answer to such questions are right. So I welcome your serious and strict implied comments or criticism. That's okay. Any kind of criticism, I'm willing to answer it. Thank you very much.
Professor Jui has agreed to take a few questions and comments, so.
So I like the talk, and I understand your emphasis on historical materialism. You're focusing on what's possible you think in China, but I'm not sure I heard in the talk why judicial independence shouldn't be a goal. So I understand you're saying because of the historical development,
yeah,
and in light of your belief that the law should really focus on what's actually good for people on the ground, it hasn't been an overriding consideration. But I'm not sure I see why it shouldn't be something that you should want to strive for. Maybe it takes a long time to get there. Maybe it isn't perfect for China now. But why isn't that?
Yeah. I got it. Actually, I want to elaborate this question, but time is too short. First thing is, if there is no independent judiciary, you don't have a legitimacy. The government have no legitimacy for the state reason. And people will not satisfied. People probably will resort more revenge, private method to address their issues. But also for another reason, because in my view, judicial independence is the non-monetary income of the judges. So if you want to, why so many people want to be a law professor? Because nobody supervises him, directed him. So at least in China, so many judges want to go to practice privately. Why? Because when you are a judge, you are supervised by your chief or president or by the party member, party organization. So I believe the judicial independence is a non-monetary, very important part of non-monetary income of the judges. So for these reasons, practical reasons, for the judges' reasons, I think the judicial independence, at least at the present stage, according to my understanding, is a desired goal.
Okay. What role do you think legal education has in terms of influencing change in the legal system in China?
Yeah. First thing, very important, legal education, you can train the more legal professionals. We saw the Taiwan the development. At the beginning, it's controlled by the Kuomintang, the nationalist party. But eventually, after several generations, the legal profession gradually developed, and the judicial become more and more independent. So I believe the legal education is very, very important. But I have to confess, I don't believe the only legal professional can solve all the problems, especially for the transforming China. During the last several years, the legal professional proposed some plans for changing the law, but eventually was attacked by the general public because they just consider the theoretical issue, but they don't pay attention to the people's sentiment. So I believe the Holmes is right. Or Judge Posner sometimes said, the judges, we need judges, but sometimes we need some lawyer and statesman. So if only legal professional training is not enough. Dean Kroman said the traditional legal profession training is train lawyer and statesman. I believe at least in present stage, China needs more professionals, but also need a field or at least a field lawyer and statesman. Just like John Marshall, the marvel with medicine cannot be done by a perfect legal profession. The John Marshall also is a statesman.
With over 14 million people quitting Chinese Communist Party, and I expect the Communists could collapse in number of days or years. What's the best way, how Chinese people prepare, transform from current situation to China without Communist Party? How do we prepare for independent judicial system?
Yeah. I don't know where you get the number. 14 million Chinese Communist Party quit quit from the party. There is some people probably they will quit their positions, but I don't believe it's necessary for the party to collapse. As long as the Chinese Communist Party want to reform China and responding Chinese common people. So I don't, in my judgment, I don't see in the near future Chinese Communist Party will collapse. The professor.
I understand your argument, and I think it's a quite powerful argument, but it has an implication that I don't think you spelled out. Perhaps you could. To achieve judicial independence, you're saying the focus ought not to be on the judiciary because of the particular history of the party's prevalence before the legal profession and the judiciary emerged. Therefore, the focus ought to be on the party. If that's true, there are other areas in which reform has succeeded by working on the party. One can think of the opening up of the economy in the private sector. So my question is a hard one. How to do it? How do you work on the party to foster judicial independence? Because that part you didn't get to.
The question is, you don't see party as a separate entity. Actually, I'm party member. Almost all my colleagues in our law school, at least 80% are party members. So it's when we develop professional knowledge, we found that this way is fair and efficient. We probably will propose our suggestion to our superior, and we will comment on party policy. So I believe this is important. But also, I don't mean in China, the judicial independence cannot develop very well just because of Chinese Communist Party. In China, so many relatives, so many friends, and including the lawyers. One of the major job of lawyers is sending the bribery the judges. So it's party. Actually, party organization sometimes actually try to keep such influence. So I don't mean such a judges, the party supervision is necessarily good. Actually, sometimes the party member or party officials will use such power for his or for her own benefit. But for China's judicial independence is not only concerns not only reduced party's power, but reduced all the other kind of power.
Basically, I have the same question as that professor. And how, in your opinion, what's the best way to make the Chinese judicial system more independent? As you said that most of the judge or lawyers are Communist Party member, and as I know that there's a lawyer whose name is Zhu, and he's a human rights lawyer, and he has been awarded by the Ministry of Justice of China in 2001 as one of the top 10 attorneys, and because he protects the basic human rights issues in China. He condemned the method of Chinese government used to persecute the people who have different beliefs like Christianity and Falun Gong practitioners. He has been secretly arrested with no reasons, and his home has been monitored by the agent from the Ministry of the State Security. So I think, in your opinion, what is the best way to become this Chinese judicial system more independent of the Communist Party?
Actually, I said so many things. Because in China, political influence is a strong influence. And political influence sometimes are very bad, even corrupting influence. But in China, it's not, we shouldn't concern only about political influence. The other social influence are also very bad. In the last few years, the judges gain much more independence. But at the same time, corrupt judges are increasing. In the Wuhan court, 2 presidents continuously was corrupt and was sent by the Communist Party the organization to investigate his cases. But recently in this Shenzhen, it's about the same. So if we look carefully, under the Mao's era, that's totalitarianism. But there's very little judicial corruption, although there's great mistakes. So when looking into China, we shouldn't just care about only one thing. There's other things we should take care of. That's my argument.
As a business person, I would be more interested in the predictability of your system rather than its autonomy. Can you assure me that the influence of the party doesn't affect the predictability of judgment?
It's very difficult to be predicted because China is so big, different regions, different judges, and the education level are different. The influence from the society and the lawyer you hired are so different. So it's very difficult to say what kind of certainty of the result you can get. But I believe China is trying to develop in such a system, the rule of law. Although sometimes I keep suspect eyes on such an ideal, because I believe the rule of law is very difficult to reach, even in the states, especially for the Supreme Court. But I still believe people want the certainty, predictability. I think probably we train more legal professionals to keep the bad influence. Probably we can achieve some result better. I don't have, I cannot promise here for 5 years China will change greatly. I cannot promise that.
In Professor Opham's law review article, there's another comment about you didn't give efforts to distinguish what is character of China and what is character of the underdeveloped countries. I see the lack of independent judiciary, the bribery and corruption of judges, all are common in all the Latin Americans or African. So how do you respond to that?
Yes, so the question is, go back to my argument. So the judicial independence is not only about the political parties. Individuality is a modern commercial society. Urban society will construct such a personality. In China, last night I talked with Dean Bartlett. I said some students will ask me to write a recommendation with a higher appreciation to the dean of other foreign law schools. I said that's not okay for me, because I should keep my honesty to the strangers. But he thinks that's strange, because I am your student. Why you cannot write a better recommendation letter to help me? So if your Suli don't write such a letter, means you don't want to help me. So in China, I found that in third world country, developing country, this is very important. You have to have such an individuality. So I'm in that sense, I'm a liberalism. I think personal libertarianism is my ideal. But I know it's very difficult in China. Chinese society is basically a communitarian society. Everybody living within a village, shared values with others, feel the pressures from the others. So that's a fundamental question for China's transformation, for China to develop a real independent judiciary, independent legal profession. Okay. I should give a female student. Okay. Yeah.
Thank you.
Yeah, I would like to ask, do you think a very transparent and efficient grassroots election for the judge might be a possible solution to foster a very independent judicial system in China? A very efficient and transparent grassroots election of judge might be a feasible solution to foster an independent judicial system in China.
Yeah, I think transparency can help the independence of China. But you cannot make everything transparent. That's the question. Some people said you should put your judicial opinion there. But I can write an opinion eloquently, but hide my real conviction, real preference. I can, you can win, but actually you lose. You win the case, but lose the money. Such kind of things. So I don't believe there is something. You cannot have just one medicine to cure all the disease. So transparency is important for China, but I don't believe it can cure all the symptoms of that, all symptoms of judicial independence. Thank you very much.
I want to once again, on behalf of Duke Law School, thank Dean Zhu for a wonderful presentation and just a terrific comparative law experience for all of us. So thank you very much. We will adjourn now to the, right outside this room, the third floor loggia. There is a reception, and we'll look forward to hearing more questions then. Thank you.